And we are recording. Welcome everybody to the second of our legal series webinars for 2020. I'm really excited for the discussion that we're going to have today regarding title insurance. We've got a great presenter and a great program for you. I do want to mention a couple of housekeeping items before we get started. As I just mentioned, we are recording this webinar. You'll be able to find it on the webinars page at texasrealestate.com once it is over. And it'll be there as an ongoing resource for you. If you have questions, we'll likely take those at the end unless they are seriously directly on point at that very moment. Please put your questions in the Q&A box and I can monitor them there. If you can, do not put those in the chat box, but only the Q&A box so that I can just monitor one of those and it'll go much easier. We'll try to disable that chat if we can, but the Q&A box for that. And with that, I am going to go ahead and introduce our presenter today. Charles Kramer is an attorney with the law firm Hunter and Kramer PC. Charles received his BA from the University of Texas at Austin and his legal degree from Baylor University School of Law in 1992. He currently serves as general counsel to the Collin County Association of Realtors and is currently a member of the Broker-Lawyer Committee for TREC. He writes the contract forms that you all use day in and day out in your real estate practice. Charles has previously served as a director of the Metro Texas Association of Realtors, as a director of the Texas Association of Realtors, and by appointment as a member of our own executive committee. That was a lot of fun when Charles served on there.
It was cool, actually. I like it.
It's always fun to have attorneys who also serve on there with me when I'm there. Charles is a proud member of the Texas Land Title Association, the Real Estate Probate and Trust Law section of the State Bar, and the Dallas Bar Association and Texas Realtors. For his contributions to TREPAC and the National Association of Realtors, he is an RPAC Crystal R member, and we are very excited about that.
Yeah.
Finally, Charles is a TREC certified instructor and regularly creates and teaches real estate classes to title escrow officers, real estate license holders, attorneys, and others in the field of real estate. And I do get to call Charles a friend and a professional colleague. So I'm excited that you're here today, Charles. And with that, I'm going to turn it over to you. We're going to present title issues. I've lost the title of the webinar, but it was title issues in the real estate industry.
In COVID-19 times or something like that.
So what we're doing. Yeah, we've got some COVID-19 in there, and also the regular issues that we still hear on the hotline every single day with respect to title issues. So with that, Charles, I will turn it over to you to begin.
Okay, so first I want to make a disclaimer. Let's talk about the word underwriter. When we talk about title underwriter, there's really two meanings to that. One is the company. So when you have a giant title insurance company such as Chicago Title, they are a title underwriter. They actually provide the insurance, and they do it one of two ways: through their Chicago Title agents or direct operations, and sometimes through fee attorneys or other agencies that can carry Chicago Title. So the term title underwriter, which is kind of the decision maker on how title companies do certain things, can refer to a company. It can also refer to a human that makes those decisions for that company. And so I'm an example of an underwriter. I help a title company or companies make certain underwriting decisions. So I'll talk occasionally about title underwriters and what their tolerance for risk is, and they're driving a lot of these decisions here. Another important disclaimer or understanding is that your mileage may vary. And what that means is that I'm going to try and set forth what I think are fairly universal title underwriting standards and title insurance behaviors and requirements, but everybody is a little bit different. Things vary across the state. Certain title companies in other portions of the state don't act the same as they do in Houston or El Paso or Dallas, so there's geographical variances. Title underwriters, and I particularly mean the humans, have different levels of risk and different experiences. So if you have been sued as a title company on issue X, you may be more sensitive to that than another title company in another portion of the state. So while these are kind of general principles, it's really hard to say that all title companies act this way or all of them have this rule. I'm going to just speak in generalities and hope that they apply to most title conduct that you watch. But keep in mind that there can be variances depending on the title company, the region, and the particular claims experience of that underwriter that you're dealing with. So with that, topic number one of the first things Lori brought up to me that she said, I want to hear, we've had some interesting disputes over commission. And when you have a commission dispute, how does a title company deal with that? Let me say that title companies in 2020, I think generally behave a lot differently than they did in 1975 or 1985 or even 1990. And what I mean by that is that in the old days, you could cough and a title company would jump and be, a title company and a title underwriter is afraid of getting sued. They don't want to spend money on attorney's fees because really title risk is not as big a danger to title underwriters as the cost of hiring attorneys. So you find that title companies traditionally have been loath to have any dispute at all. They don't like to, if there is a dispute, then they run into their shell and they say, we can't make a decision and we can't do anything, we'll have to hire an attorney. And so that's how the proud tradition or the strange tradition of title company behavior in the midst of disputes where you see them declining to answer the legal question is because they have to hire attorneys if there's a fight, and it doesn't really matter whether the title company's decision is correct or not. That's kind of a guiding principle behavior. But I will say that in 2020, more and more frequently, escrow agents, and I use that term as a title companies and escrow agents are working more and more in terms of black and white, following the contract, following the things in front of them, and that's a good thing. So for example, if you have a contract that shows broker A on that contract is representing the seller and broker B on that contract is representing the buyer, and some complete stranger to the escrow that no one has ever heard of, broker C, walks in the day of funding and says, I'm entitled to a commission. Some title companies might choose to say, look, the contract is our roadmap. This is what we have to follow. I have to follow and receive the instructions. And if you claim that you're entitled to commission, I don't see it here. I can't stop the closing. That would probably be the worst thing for a title company to do. I can't stop the closing for the claim of a complete stranger to our escrow. So a frequent and hopefully common response of title companies would be to ignore that claim unless that broker retained an attorney and maybe filed something like a lawsuit or a temporary restraining order. But if you're a broker and you say you're entitled to money, I might ask you, just because I'm holding the money and it passes to another broker doesn't mean that your claim has gone away. Are you entitled to that particular piece of money at that point in time? Maybe not. You're just entitled to money. So why is it so critical that you freeze the deal right there? Your claim still exists. And so I might, in the absence of a lawsuit, choose to ignore you as a stranger to the escrow.
Let me ask you a question about that,
Sure.
Charles. Well, first a comment and then a question, because I do want to point out that for real estate brokers and agents, they should not be inserting themselves into a situation to stop a closing either. That should just not happen.
Yeah.
They should try to preserve any arguments they have and deal with that without stopping that transaction. So that was my comment. But my question is, I think your example centered on a broker who came in to challenge another broker's commission out of that. What about when there's a dispute between the listing broker and the seller as to how much is supposed to be dispersed out of the seller's proceeds to their listing broker?
Well, there are some rules that we can use to help clarify that. and at the title company level, when we see these things, we distinguish between broker who has the broker's license or broker of record, who is in a sense God. They control the commission. They are the ones that we have to obey. And the sales agent or license holder who may be getting the largest piece of that commission. And while the license holder may be in the real world, the tail that wags the dog, and they generate all the money, and their brokers hope to please them. In a legal sense, the broker of record that holds the broker's license has 100% control and say over the direction of that commission. So when we get into that sort of fight, the title company should look to the broker and say, what are you telling us to do? No, never mind your sales agent, but what do you want us to do? And if the broker gives us instructions and the sales agent or license holder doesn't like it, we can say, look, the law is very clear. Your broker has given us a written instruction to pay this amount of money. You may disagree with it, take it up with your broker, but we'll sometimes look to diffuse or escape those fights by going straight to the broker and getting their written instruction, because the broker really does control 100% of that. That's one way we do it. If the broker and the license holder are on the same side and they say, well, look, I was supposed to get this fee of X%, and the seller says, no, you weren't, and we have a genuine dispute, then I need, as an escrow agent and a title company, I need the claims reduced to writing. I need something that bangs into each other. So I might have the CDA in my file from the broker that says, pay me X%. And so I might turn to the seller and say, if you don't want me to pay it, number one, I got to have something in writing from you demanding that I not pay it. So I need a written, I can't just refuse to pay on your phone call. You need to send me an email or a letter or something like that. And then once I have those two conflicting demands, then we got the classic title company answer of, we're not a judge or jury. We don't, A says this much is owed, the other party says no. We've got two conflicting written demands. We need to hold the disputed amount in escrow. We want to escrow. And most of the time, the broker who wants the money and the other party who maybe wants the money for themselves will agree to a short period of escrow. Now, we're not gonna have the broker and the seller, for example, sign an escrow agreement that says, you may escrow this $6,000 with us for as long as it takes to resolve this. I'm not going to agree to hold that money for 2 years or 6 years or whatever. It'll rot, and it actually causes a title company expense to maintain that money and report it to their auditors and give all these detailed explanations. So I might give the parties 30, 60, or 90 days and say, look, if you guys haven't resolved your differences on who gets this money or how to split it up at the end of 90 days, then I, the title company that's holding this bundle of disputed money, hereby agree that we will pay it to X. Maybe I can put it in the registry of a court, which might mean I have to hire an attorney and file what's called an interpleader action. I don't like to do that. It costs me money. Maybe I say it goes to the broker and the parties don't eliminate their claims to the money, but I have to get it out. I'm not going to agree to hold it forever. So an escrow is kind of a diffusing of the situation. Gives the parties the time they need to negotiate or do arbitration or whatever. But I've got to have some clear rules to follow and a fairly short timeline. I'm not going to agree to hold a sum of money for 1 or 2 years while you guys pound it out. It's going to have to go somewhere at the end of the day. And lastly, sometimes I have no choice. I mean, if it's just an absolute feud and the broker has brought in their attorney and they've sent me a demand letter, and let's say the seller has brought in their attorney and they've sent me a demand letter and I've got to hold that money, the first choice that title companies will seek to try and do is get an escrow agreement that is signed by each side, which defines how we hold the money. But there is occasionally situations where it's just so white hot and in such dispute that everybody agrees the deal should close. The attorneys for the broker, the attorneys for the seller, and the title company says, let's close it. But I can't get agreement on how long we're going to hold it. So we might just hold it in escrow without an escrow agreement. That's the least favorable and desirable thing to do, but you don't want to punish the seller and buyer and prevent the closing of a home over what is really a small piece of money in relation to the transaction. So that's the last thing. But I've got all these other tools in my toolkit to diffuse the situation. Go to the broker for their command. Perhaps enter into an escrow agreement with the parties. But what we can't do as a title company, and what I think is really wrong, is for a title company to fold its arms and say, sorry, we can't close until this dispute over $2,000 is resolved, and buyer, you can't get your home, and seller, you can't sell it. That's the wrong answer in almost every instance. You have to find a way to close the deal.
We had a great question on this topic come in from one of our participants. So I want to ask it. I know after this, we probably need to move on to the next topic, but this is a great question. How does the title company view or deal with the written listing agreement that is between a seller and the listing broker? If perhaps there's a dispute as to how much of the seller's proceeds are supposed to go to the listing broker, would they take that listing agreement as that written document that you were referring to earlier?
Yes, we try and be as black and white as we can. Now, title companies don't normally see listing agreements, but if the listing broker says I'm owed X percent, and here's my listing agreement that says I'm owed X percent, we can play a little bit of ping pong. The title company can be the ping pong ball and turn to the party contesting and say, here's the listing agreement, here's the CDA we've received from the broker. It's very plain, it says X percent. Why are you saying you don't owe this? And if the answer is just grumbling, like I don't want to pay it, they're a jerk. I might, if they don't have counsel, might ignore the demand and say, you haven't presented a legal basis for me to withhold it. So you're just upset. I can't hold back money that is duly entitled under a listing agreement because you don't like them or they made you mad. Now, if I do that ping pong game and the seller or their counsel presents some legal basis, like we orally modified it, or we did this, or we agreed to change, or we encouraged, if they set forth some legal basis, I might not agree with it, and I might say that the evidence is weak, but that is enough to get them into court and to have me spend attorney's fees. So I might turn back to the broker and say, look, they're telling me their legal basis for not paying this is X, so I can't be a judge and jury here and say, you're right, they're wrong, you get the money. I'm going to have to hold it based on their legal interpretation or the interpretation of their counsel. So we have to distinguish between claims that are just griping and claims that have some tiniest legal merit. Even if ultimately they're going to lose in court, what could cause me to be in a court of law between this seller and this broker? That's kind of what I'm looking at as my standard. So.
Okay. If okay with you, let's move on to the next topic.
Okay.
When I introduced you, I mentioned Broker-Lawyer Committee, and I think
I've got that next on my list, contract changes. So now we might put up, there are a lot of contract changes, but the one that merits the most discussion and attention and perhaps revision is this new way that is being proposed to handle the option fee. And I don't know if Robin or Chelsea can put that paragraph up. Let's see if we can get that up so we can all look at it and talk about it. Now, as we're waiting for this, it's important to know that this is a proposed change that is under public comment. It is not one more. It's the other one. There we go. Yeah. And I hope everybody can see that beautiful yellow color. But this is not a guaranteed thing, people. This is under public comment. So if you have opinions on how this should be reworded, if you don't like the change at all, if you love the change or whatever you feel, you have every right and should, in fact, send your written comments to the General Counsel for TREC. And that email address, if anyone is writing it down, is general.counsel, COUNSEL, at trec.texas.gov, G-O-V. And that goes into a special email box that's monitored. Those emails are all printed. This change was proposed at the May 4th meeting. Lori was there or participated, so that's roughly the date. Texas Realtors did not want it to go forward. There was quite a bit of discussion back and forth. Ultimately, the Texas Real Estate Commission decided to publish it and at least move the forward process with public comment. The next thing that will happen is that the Broker-Lawyer Committee will meet probably electronically, like a meeting like this, on July 17th to look at all the comments about this and consider whether it needs to be scrapped, changed, reworded, put on the table, or maybe just say, no, it's great. There's all sorts of options there, but we will look at all the comments and talk about it. the big summary of this change is that it gives the ability for the agent, for the buyer, or the buyer, either one, to deliver the option fee to the title company along with the earnest money. And just as a listing broker has the ability as the agent of the seller to receive and receipt the option fee, which has always been the law, we can modify the contract to make the escrow agent for not only the earnest money and the agent of the seller for the earnest money, but also the agent of the seller for the option fee. And I would point out, for those that think this is really radical, there's a flavor of this, a very strong imitation of it in the commercial contracts of Texas realtors. And in fact, it has been it's not a rare thing in commercial deals for the seller and buyer to say X dollars of the earnest money is the option consideration. They don't call it an option fee, they call it the independent consideration, but legally it's the exact same thing. It's the money paid to support the buyer's look and the buyer's right to terminate this contract. So our experience in the title industry has been that we've been able to handle that concept for, I don't know, 15, 20 years, however long it's been out there, for fairly well. And when a deal terminates, the title company, typically in commercial deals with this type of language, will simply send that option consideration to the seller, and they send the earnest money back to the buyer, and there's no questions and there's no releases, and it's just an automatic, very mechanical thing. So we thought, given that agents seem to be having continued trouble based on the reports from title companies across the state, that and we can go into, or we won't, but you could have a discussion as to, are we changing the contracts because license holders are not doing the right thing? They shouldn't do this. But what is happening, the reality is that a lot of option fees are being tendered to the title company against the wording of the contract, and the title company is being told, I'm a big customer. If you want my business, you'll get this over to the seller. I'm very busy. And the nature of the business is such that a title company might be presented, especially in your smaller parts of the smaller markets, might not have the power to say no to the agent, and it jeopardizes when you do this, and it's not authorized. But if we don't change the contract, then this practice, which seems to go on all the time, is very dangerous for the agent. It's dangerous for the title company. It's dangerous for the seller. It jeopardizes everything. So we thought, why don't we legitimize the practice by contract and perhaps allow the parties to do the option fee as well as the earnest money. Now, there are some things that we need to think about, and Lori and her group at Texas Realtors have outlined some of the concerns. And if you want to talk about those now and say, and just, in terms of question format, we could bullet point those thoughts and concerns you have. I don't have great answers, but it will get the listening audience thinking about these issues. And you could do that if you wanted to. But I think one of the concerns was, if you have, just use simple numbers. Let's say you have $5,000 earnest money and you have a $500 option fee. Will the agents really remember to deliver will they be delivering a $5,500 check is the question. Will they deliver a $5,000 check and a $500 check? How will the logistics, what happens if you deliver the $5,000 earnest money and you erroneously think, well, the option fee is included in that, and you haven't delivered the required $5,500 earnest money? What happens? What happens if it's delivered late? What if they're two separate deliveries? So, there is some hair to think about, but I might say that all of these issues with late delivery, missed delivery, non-delivery of the option fee might already be occurring where the receiving party is the listing broker. And so they just transfer who has the burden to deal with these issues. You want the listing broker to deal with these issues, or do you want the title company? Either way, and there may be even though this change is favored by the official trade organization of the title industry, the Texas Land Title Association, there may be many title companies that don't want this, that are against it and feel that it's going to increase their burden. So we may have a difference of opinion, but this is a big change in the way we practice, and it may or may not go through depending on the flavor of the comments and the opinion of the state.
So Charles, I'll just add to that we did issue a letter of concern, which I did via Zoom or whatever that platform was during the meeting.
Yep.
And it wasn't the overall idea, but it was these questions that Charles has expressed here. We wanted some more discussion around that, and perhaps a little bit different language used in the drafting. We have supplied TREC with our commercial contract language that seems to be a little bit cleaner, and still have not determined whether our members support this or not. But if it's going to be considered, we wanted to ensure that it was done in a way that we would be comfortable with if that's the direction we went in.
And I agree with you. I agree totally that the language that's been sitting around in the Texas Realtors commercial form is well established, easy to understand, and has been in good use and practice. It's a great model. This language was drafted by a subcommittee. It's the first time in my 10 or so years with the Broker-Lawyer Committee where we broke off into writing committees rather than struggle with 12 people trying to write the same thing. We just had 3 drafters, and they came back to the whole committee and we looked at it. And the guiding principle, and I kind of like it, is to, rather than rewrite the paragraph, which we may have to do, but Ron Walker especially, who's got the longest history with the Broker-Lawyer Committee of anybody, the longest tenure, is a strong proponent of trying to change the language as little as possible from what agents have been using and realtors have been using, so that there's less change and less education. So if we can get from point A to point B with less change rather than more change, that's a drafting principle that we want to try and abide by. It may not work. It may be that we just have to rewrite the whole thing or use something out of Texas Realtors commercial form. We're still in discussions about that, but it might help agents with this burden. It might be something that the title industry is saying, it's already happening, we're already having to deal with it, so let's just legitimize the practice and try and make it a fairly routine thing.
Well, that's a good point, Charles, that sometimes the contracts are updated to reflect practice, and that's not necessarily a bad thing. That's not rewarding people that didn't do it right, but the contracts are intended to reduce conflict, and if the practice is moving in that direction, that's up for consideration.
Yeah, definitely. You got a lot of lawyers, especially, tend to be very high and mighty, and they tend, when they see practices which they deem as bad or improper or which violate the contract, they say, well, you just shouldn't do it. Just that's your fault. And if a practice in violation of a contract term occurs over and over and over and doesn't seem to be changing, then you got to change your mindset to say, maybe it's the language, maybe it's the wording of the contract that society and the real estate industry is rebelling against. Maybe we need to change our thinking rather than just say naively, everybody needs to follow the contract at all times. So yeah, I agree with you.
I would also say, if you still have concerns, for those of you on here, you can email me as well. And I can take those into consideration. I've been responding to some of your questions just to the individual that asked, as opposed to bringing them up so that we can continue to move along on this webinar. With that,
and I should mention in terms of timing, so if the Broker-Lawyer Committee meeting is July, the first possible TREC meeting that might adopt that is sometime in, I think, August or something like that. August. And so we've got all summer to look at this and talk about it and receive comments. And the very fastest that I could envision this happening might be adoption at the August meeting, and maybe they don't go mandatory until the end of the year, the beginning of the new year. So we got a lot, and it may not even happen that fast. It may say we need to TREC it. It's Broker-Lawyer Committee might decide to hold them back. You know, I don't know what's going to happen. So I don't want anyone thinking this is an imminent, permanent change that's coming. It's It's an imminent discussion that's being undertaken. So let's talk.
Do you want to move on to T47?
Yeah, I don't know if we're going to get through all our lists because I'm such a wordy blabbermouth, but let's talk about T47. Can we pop up the T47 affidavit? And let's talk about this thing. There it is. Okay, the famous T47 affidavit. So the dilemma that many agents and the questions that I get are concerning paragraph 4 and this big blank. Since blank, there had been no, and you might just say, changes to the property. Okay, the survey reflects everything that's on the property, except, and you can see that you have the ability to carve out certain things. So if you have a survey from 2017 and you're selling a home in 2020 that you bought in 2010, and since 2017 you've replaced the fence, then at the end of paragraph 4 where it says except, you could put replaced fence in 2019, and that would tell the title company and the buyer, hey, the fence shown on the survey is not the fence that's out there. It might be in a different location. Okay, so the affidavit is flexible enough to allow the seller to document changes since the date of the survey. The problem that is occurring now is that this practice, which I will tell you in a few minutes, I think is a bad one. I personally don't like using old surveys, but it's been so pervasive and common in our business that we're getting to the point where sellers are providing the survey that their sellers provided to them in the prior transaction, or even sometimes 2 sellers ago. So you could have a sale in 2000, a sale in 2005, and a sale in 2010. And you could have that 2000, now we're selling again, 2020, and our seller, who's only owned it 10 years, might be providing a 17-year-old or 20-year-old survey that is 2 owners back. And so the problem becomes when you start to use 2nd-generation surveys and 3rd-generation surveys, whatever, the title companies will have a greater tendency to reject them, saying, look, this seller doesn't know anything that was on this survey 20 years ago. And so to combat that rejection rate, I'm seeing some agents and brokers say, look, what you need to do in paragraph 4 is that date that you fill in, that needs to match the date of the survey. And that way a title company won't reject it. And that's a great thing, and we'll have all our smooth sailing. Well, that's wrong if you haven't owned the property since the date of the survey. You're swearing to, these are facts that you're swearing to. And number 2, we are familiar with the property improvements located on the property. It is improper and dangerous to swear of facts that you don't have knowledge to. Okay, and by the way, it doesn't really work because the title company is going to see the whole picture anyway. If you put the earlier date, but the title company sees your deed from 3 years ago, they're going to know that this is a 2nd or even 3rd-generation survey, and they're probably going to reject it. So to answer everybody's question, the date that should be put in paragraph 4 is the date you acquired title to the house. That's when you have your knowledge. That's when you know, since I took title, there have been no changes as shown on this survey, or if there have, you can put that there. So I think that should be pretty clear. But bigger picture, should you be doing T47s in the first place? Let me give you an analogy, because we do this T47 to, quote, save the party's money. We don't want to spend money on a survey. It might cost $400 or $500 on a standard residential deal. So we're going to save the money. We'll just take the seller's old survey. We'll put an affidavit. I got a great idea. Rather than getting new inspections and hiring an inspector and incurring all that money, let's just take the seller's old inspection reports. We'll put an affidavit on top that says, to the best of my knowledge, nothing's changed since the date of these inspection reports, and we can save all that money. And the point is that due diligence, which is what a buyer does to check out whether a property is going to be good for them, requires that you spend money. You have to spend money to kick the tires. And if you drop $1,500 on a house and ultimately you terminate, that's the best $1,500 you ever spent. And so I believe that a new survey in which a surveyor represents to you, the buyer paying for the survey, that those are the boundary lines and this is where the improvements is worth it. It's worth it to spend money. That's new survey is a good thing. And that saving money on a survey has limited use. It's common. I know that I'm not going to reach everybody, and there are people that are probably real mad right now saying what he's suggesting is heresy, but I do believe in spending money on due diligence as a buyer. And if we got out of this paradigm and we just did more new surveys, and I don't have, by the way, I don't have any ownership interest in any surveyor. There's no surveyor in my family. I just happen to believe that that if I'm buying hundreds of thousands of dollars of real estate, I should drop a few $100 to have a surveyor represent to me that these are the boundaries and these are where the easements are located. You know, we need to question when we are going to use this and is it proper? And especially in the case of surveys that are getting 2 generations, 3 generations old, and we don't really know anything. If we get more into the practice of using new surveys, then we don't have sellers and listing agents running around trying to find a notary. We don't have to worry about what date we put in here. We don't have to have the nightmare of promising in a contract to deliver an existing survey, and then your seller tells you days later after they sign the contract, I can't find it. And you suddenly are buying a new survey. You get out of all of the complications that come with the used survey and the T47 affidavit. On top of that, you can get tighter title coverages when you have new surveys, that it's easier to get survey amendment coverage if you have a new survey than when you have an existing one. So while we're talking about the T47 affidavit, I want agents to think, do I even want to do this? If I'm representing a buyer, is it in my client's best interest to save them the most money as humanly possible? Or should I recommend that they get a new survey every time? And you can recommend it. And if your client says, no, I don't want to spend the money, then it's now they have made the decision instead of the broker making the decision for them. So that's just my personal view on used surveys and T47s and what you should fill in.
Charles, we had one question come in. Does the analysis that you just provided change if you're talking about a farm and ranch property versus residential?
Yeah, a little bit. I might suggest that, especially with significant acreage, that those properties are less cookie cutter than residential lot and blocks. And so we might say that a residential lot and block property being sold is more suitable to a used survey than a 600-acre ranch that's been in the family many hundreds of years. The survey that is being produced in a farm and ranch might not be 20 years old. It might be 50 years old. It might be even older than that. And while, you know, monuments and boundaries generally don't change, they can in the case of farm and ranches if the monuments or the corners of certain lines are trees that can get cut down or diseased. Bodark markers are very common in the country. And so I get more on my soapbox for large commercial properties and large farm and ranch than I do for a lot that was platted in 2017 from a family farm that's been there forever. You know, that's much more cookie cutter. So I do have a difference about that.
Okay. Let's keep moving on so we can get to all the topics that we identified. How about FIRPTA?
FIRPTA. So what is FIRPTA? In case you don't know what that acronym stands for, it stands for a federal law that was passed in 1980 called the Foreign Investment in Real Property Tax Act. Title companies call it FIRPTA. And it's a way of collecting a tax on sellers of real estate in the United States who may not otherwise be in the U.S. tax system. They may be in the U.S. tax system, but the idea was that if you have a foreign corporation or foreign owner of real estate and they sell their property and they take all their money and their net proceeds and they go offshore, we've never captured any kind of capital gains tax. We've never captured any other income tax on that. It's not fair. Our own citizens are being taxed heavier than the foreign owner of real estate. So the law is, and I'll give you the basics of the law, which by the way, has been around since 1980. And so it's not new. And the way, it's been revised slightly to change some percentages of tax, but it basically says that if you are a seller of real estate, whether residential or commercial, and you are not a U.S. citizen, we're gonna stick to residential and talk about people rather than trusts or corporations or LLCs. I don't want to get into the weeds on that. But if you are a seller and you are not either a U.S. citizen, and that is defined as someone who's born in the United States or been naturalized by raising your hand, taking the oath, or you have a green card, you are what's called a permanent resident alien. If you're not either a citizen or a green card holder, then this tax may and arguably does apply to you. And what is the tax? The tax is either 10% of the gross sales price or 15% of the gross sales price, depending on the size of the property, the purchase price of the property. Now, there are some big exceptions to FIRPTA, where even if those two things apply, even if you are, or even if you're not a green card holder or not a U.S. citizen, you might not owe any tax. And the big one that was used until fairly recently all the time, which kept a lot of FIRPTA deals from triggering, was that if the sales price is less than $300,000 and the buyer is going to move into that home as their residence, and maybe you call it homestead, that no tax is owed. That's not a foreign, that's a sale to a U.S. citizen, and we're going to, just for policy reasons, we're going to carve that out of the law. So even though they are a foreign seller and they technically would owe the tax, you don't have to do it where the buyer's going to move in and the sales price is less than $300,000. And we can confirm that through affidavits and those kinds of things. There's another more complicated exception to the law involving residence, and you can not owe any tax if you have lived in the home, if you've had a substantial presence as a seller in that home. And the substantial presence test is a complex formula. And here's the dangerous part. If the tax is not collected at closing and remitted to the IRS, and it is in fact owed, the liability for the tax, even though it is a tax on the seller, the law is very clear that the liability falls on the buyer. The buyer is expected to collect this tax, and they collect it by having the title company withhold it at closing and send it to the IRS. What we do is we make the buyer, who is not the foreign person, but the collection agent. The IRS says, look, we're not going to chase these foreign sellers in other countries for our money. So if you don't collect it, and you're supposed to, you owe the tax, and by the time we find you, any penalties and interest. It's a big thing to think about. It's a big liability. So you may wonder, well, how come I'm just now hearing about all this? If it's been around since 1980, the reason is that, remember the big exception to the law, sales price under $300,000, buyer's going to live in the house. Well, in 1980, your average sales price of your home could easily be under $300,000 in the majority of circumstances. And two, in 1980, we just didn't have as many foreign owners of residential real estate, but the world is changing. And you have a lot of multinational corporations that for various reasons are locating in the United States. And so if you have a company like Samsung, for example, that moves 500 people from Korea, Japan, or somewhere in the Far East, and they say, we're going to bring them over, they're going to buy houses, and they're going to get work visas, and they're going to be here a minimum of 5 years, those people might not be or become U.S. citizens, but they are going to become homeowners. They're going to work for this company in Houston or El Paso or Dallas for 5 years. And so they get processed for these visas, but they're not citizens and they're not green card holders. And therefore, when they go and sell these houses, FIRPTA applies to them. So we're just in a different world in 2020 than we were in 1980 or 1990. We have a lot more foreign owners of real estate that aren't citizens. And so this gets triggered more often. Now, before everyone runs away in a panic and says, oh my gosh, I got to think about this all the time, your beautiful TREC contracts have been dealing with this since 1980. And one of the great things that a buyer can be assured about and rest assured is that the tax is not owed if the seller delivers an affidavit, a special form of affidavit, or we might call it a certificate, there's some dispute as to whether it's a sworn statement or just a certificate, but I'm going to say certificate of non-foreignness. You know, if you swear that you are not in fact a foreign person as defined by the Internal Revenue Code, and you deliver me that at closing, then I can rely on that and believe it, and I don't have to collect the tax. And that non-foreign certificate delivery is buried, I think it's in paragraph 20. If you want to see it, let me look real quick. Paragraph 20 is the provision of the TREC contract that requires every seller to deliver a non-foreign certificate. And folks, you may not have realized it, but since 1980, your sellers have been delivering this as part of the title company junk docs, and it's there in every deal. And maybe in 1 in 3,000 deals, you have a seller that says, I can't sign this. I'm not, in fact, a green card holder or U.S. citizen. And then we jump into the FIRPTA analysis. Is a tax owed? Do we need to deal with it? The big issue is title companies, because I would say there is not a consistent approach by title companies as to this issue. Some title companies will act as the traffic cop for FIRPTA. And when they flag a FIRPTA scenario and say it looks like withholding by the buyer is required, they will do it, and they will force the withholding and send the check to the IRS and protect the buyer. Some title companies don't like the heat, and if we have a buyer that says, looks like there's withholding due, and the buyer says, I want to withhold because they're not going to deliver a non-foreign certificate as required by the contract, and the seller says, no, I don't have to deliver because I meet this substantial presence test and you'll just have to believe me. What do? There are some title operations that say, look, we won't withhold. Here's a piece of paper. Buyer, hold the title company harmless. Seller, hold the title company harmless. Y'all figure it out between yourselves. And that has some risk for a buyer, because if in fact the seller is incorrect in their analysis and they think that they don't owe the tax, and in fact they do because maybe they missed a little piece of the substantial presence test that would have gotten them out of the tax, the IRS, if they audit this file, is going to come after the buyer, and the buyer will owe the tax, penalties, and interest. And the buyer can look at themselves and go, why did I believe that seller? Why did I sign a hold harmless? Why didn't I just stick with the contract and make the seller withhold if they're unable to deliver a non-foreign certificate? So that's how FIRPTA works its way into modern deals. I think buyers and sellers should pay attention to this paragraph 20. It doesn't pop up that often, but when it does, it's fairly black and white on how it's supposed to be dealt with. And I think withholding is required at closing, and I think a buyer can stand their ground if they want. And here's one final piece of this. Let's again go back to the substantial presence test, which is the most common claim by sellers who are not U.S. citizens or green card holders, that they don't owe the tax. And a buyer doesn't know what to do, and they don't know what to believe, and they don't have any way to independently verify any of this. The buyer can say, look, the contract says you have to deliver a non-foreign certificate. You're unable to do so, so the contract contractually permits me to require withholding. Now, if you truly don't owe the money, you can file an application for something called a certificate of withholding, and you can send it to the IRS, and you can get a refund of that money back to you that was sent by the title company. So we're going to withhold, we're going to send it to the IRS, I say IRS, Department of the Treasury, and you and your CPAs mess with that certificate of withholding, and you get the money back if you're not in fact taxed in reality. So there's no harm in that. And that's kind of the pressure release valve that we sometimes suggest to the parties in these hotly contested situations.
That is great information on a very confusing topic. So
Yeah.
Thank you for that. We've got about 11 minutes left, but let's move on to title objections.
Okay. The section on title objections is in paragraph 6D, as in dog, of the contract. And I recommend that every agent that feels fuzzy or weird about this, like, what do I do? How does this work? Go read it, because this is your guide to how it works. It's a dance. And for example, when you buy a new home from a builder, you may not have the contractual right to object to the title or object to the survey. You just get what they give you. But the TREC contract's very fair and balanced in this thing, and it says the buyer has a right to review the title work from the title company and the survey and make objections to one or both of those. And the written objections, and by the way, the number of days to object is that little blank in paragraph 6D, not the long one, but the little one. What should that be filled in with? How many days does a buyer need to look at title and survey and make objections? I would say that the statewide typical number is about 3 to 5. I've seen more days. I don't think 1 day is enough, especially if title work were delivered on a Friday and you need to get a hold of an attorney to look at it. But 3 to 5 days is about, in fact, a good real estate attorney can look at title and survey of a residential deal in 30 to 45 minutes and tell you whether there's anything wrong and make objections. So it doesn't take that long. I don't think you need 30 days. But if you think about it, the stuff in title, especially the easements and setbacks, are shown on the survey. So you really have to have both. You have to have the title work, which comes out first, and then you have to have the survey, which comes out next in the case of a new survey. And you look at both and you make objections. And then the language goes on and says the seller has to fix or cure those objections. And if they can't, it allows for an extension of the closing date. And if by the end of that extended closing date, the seller can't or won't cure those objections, the buyer has the right to kill the deal and get their earnest money back. So it's a bit of a dance between seller and buyer, but it's important that agents understand and know how this paragraph works. I see agents that leave that number blank under the erroneous interpretation that if I leave it blank, I've got all the way until the closing date to make title objections. And I will tell you, that is simply an interpretation. Maybe a judge, if you're fighting in court, would buy that, and maybe they wouldn't. But we don't want ambiguities in the contract. I do think something needs to be filled in there, and it needs to be some reasonable amount of time for a buyer to object to survey and title. So 3 to 5, 5 to 7, something like that. What goes in the long blank? The thing that we've been seeing since about 1979 is residential use. Now, I will say that if you're buying a single family home that's lived in by the seller, it's probably zoned and approved for residential use. It's kind of a meaningless statement. On the other hand, if you're a buyer or a buyer's agent, you don't need to get into a huge lather about this and, oh my God, this is so offensive and I can't believe you're so dumb, and you just let it go. But it's when you put residential use on the sale of an existing single family residence, it's a nullity. You're not saying anything. It has to do with use. What are you going to use the property for? So if you're buying a single family residence and you intend to use it maybe as some sort of public place of business, you've ever seen businesses that are situated in little homes, you might want to put, use as a barber shop, use as a law office, that kind of thing, if you've got a special use. If you're going to do anything at the property that is other than ordinary living in it, such as I want to be able to keep chickens, I'm a beekeeper, I want beehives there, something where local ordinance or recorded restriction might prevent a strange use, put your strange use down there. I'm gonna have horses out here, so I want the ability to keep a horse or something like that. Chickens are the big popular thing these days. So
yeah. So Charles, in the few minutes we have left, I want to make sure we cover COVID because we did promise that. So
sure.
Can we talk about notarizations, remote notary?
Yes. So there is a new law that got passed a couple of years ago, but really the Secretary of State didn't promulgate any hard and fast rules until fairly recently, but it allows for something called a remote online notary, RON, we call it. And since the COVID crisis began, the RON has exploded in popularity, and it's great to see the legislature pass a law that actually works and is getting used, and it really is getting used. And if your title company is not familiar with RON, see if they can get familiar, because there are RON vendors that they can hook up with and employ. And what the RON is and does, it's a notary, a state of Texas notary, that has a special RON license to allow them to notarize a document remotely, meaning that the person signing the document is not standing in front of the notary. They're in a kind of a Zoom type interface. They're appearing electronically, and they're not going to sign the document. The notary has got the document, and so the document is electronically signed by the notary, and the notary affixes the electronic signature of the signing party after they go through the notary process. It's a fascinating and really cool thing. You can be in a foreign country and you can do the RON because the RON is a notary in the state of Texas. And so you got to get your hours straight and be up at the same time. But the RON process requires certain things that the notary has to do to authenticate that the document is authentic and that the person that's appearing in video is authentic and it's really them. And what's really interesting is that the RON service that we're using and that our title companies are familiar with requires the party that's going to use that to have a credit history. It uses credit history as a way of authenticating that that human out there in cyberspace is a real person. So if you don't have a credit history, then in some instances the RON may not work for you. But that's one way of authenticating. It's not just hold a driver's license up to the camera. They've got to go online and verify that you are who you say you are. So that verification process is really cool, really interesting, and it works. It works well. Now, if for some reason, let's say you don't have a credit history or you don't have the required technology to do a RON, there is another thing that the governor of the state of Texas has permitted by emergency order, which is called by some title companies a RIN, or remote inked notary, RIN. And that is where, let's say I am the party signing the document and Lori over here in Austin is my notary, and I can't make it to closing or whatever. I have the document in front of me. I'm going to sign this deed. And so I literally sign it, and then I hold it up, and we use a Skype or a Zoom interface, and I hold it up so Lori can see it. Lori goes, okay. Then I do hold up my driver's license, okay. And Lori may have some additional verification questions to make sure that I'm not my brother faking, who looks like me. And then Lori will be able to notarize the document once she gets it remotely. And so it's an inked, you use wet ink to sign the document, and the notary is just in a geographically distant place. That is permitted by many title underwriters if RON doesn't work for some reason. And the order by the governor has just been extended through June 30. So we might want to check back to see if it's going on through July, but that's another great alternative in COVID times when you can't get into the title company or don't want to. Ask your title company if they can do this RON or RIN notary procedure. If you can't do that, you might do drive-up closings where you just literally drive up, you stay in your car, the closer runs out, looks at your ID, has everything ready. That's wonderful too, because there's no more, sitting in the closing room for 2 hours. You got your air conditioning running, maybe you got your McDonald's next to you, and you sign and go. And so we're seeing more drive-through closings, and that's a great thing that realtors, closers, buyers, and sellers are adapting to these hard times, and it hasn't slowed us down. We got progress and we got closings. So it's fantastic that we can do this.
Charles, that is great, because I know initially when COVID-19 came on, we had heard that a lot of title companies hadn't gone through all the steps to get certified for RON or whatever that process is called. And it's not an easy process. No. The legislature did make it difficult. So we were encouraged by the governor's order that allowed for those additional steps. And then you're right, the drive up or drive by closings, there really is no reason that a closing should not be able to happen in the state of Texas. So if our members are running into that, they need to ask these questions of their title company or talk to a different title company.
Talk to a different. If they can't do it, find someone who can. That's the great thing about competition in this business. You can get your deals closed.
We are right at noon. So I want to thank Charles. I know that our participants enjoyed this, Charles. I will say that you didn't wake my dogs up, so you can take that as a compliment, I think. They slept through the whole thing. They like your voice. So I do want to thank you, Charles, for being here today. We really appreciate it. We will do this again sometime because these are all topics that we could talk about for many, many more minutes than we spent on them today. But this was intended to kind of hit a bunch of hot topics, and you did that for us. So thank you very much. And this will be recorded. It was recorded, and it will be posted on our website either later today or tomorrow. So with that, goodbye, everybody, and we'll see you next time. Thank you,
Thank you
Charles.
so much, Lori. Bye, everybody.